Good evening, this is John Milburn for Laws 12067, Environmental Law. This is Term 3, 2017. We're now into 2018. It's week 9, and this week we're dealing with environmental litigation with an emphasis on civil law. Next week we'll deal with issues to do with criminal law. Before we start, just some comments in relation to the assessment regime. So as you're aware, the first assessment was due on, as I recall, the 11th of January. The second assessment is due on the 25th of January. My assessments during term typically are due on a Thursday evening, 11:45 p.m. As you may be aware, my philosophy is to provide feedback which is hopefully comprehensive in a reasonably quick time. So my commitment to you generally is to provide feedback some 9, 10, 11 days after the assessment was originally due. That means that typically I put in a requirement for you to submit your work, even if it's late, by a certain cut-off date, which is the Saturday week after the assessment is due, in other words, 9 days after the assessment was first due. The reason for that is that on day 10 or day 11, typically, I can then release the results and feedback to students. And that hopefully will come just in time for you for the first assessment to provide something meaningful and of assistance for the second assessment. So what's this second assessment all about? This is where we're looking at environmental law in a much broader perspective. And as you can probably tell, environmental law can be viewed in a number of ways, internationally, at a Commonwealth level, at a state level, at a council level is one way of looking at it. Another way of looking at it is to consider the type of environmental procedures being undertaken. So whereas in the first assessment we were dealing with issues to do with, say, cases and legislation, in the second assessment we're now looking at a case study. And this is a live study. This is the Townsville Port Expansion Project application. Your overall requirement is to provide an answer in less than 1,500 words in total. Now that's not going to be easy because there is, quite frankly, a massive material available to you over the internet in relation to the Townsville Port Expansion Project. Because this is a moving feast, as it were, what was contained in the original material, the original summary, is modified as a result of the impact of the environmental impact statement. So what I would like you to do is to consider the material effectively as it is now to the extent that you can. So by that I mean, if material has been amended, updated, and you have an opportunity to comment on those updates, please do so. Obviously, when it comes to the Townsville Port Expansion Project, there is the matter of the additional information to the environmental impact statement, the summary, which I've provided a link to you, and that includes the terms of reference and the original application. The task in some ways is quite simple. The first task is to provide a background. So give me an overall summary of the application proposal, provide a short summary of the proposed project, its stated benefits and likely impacts. Now, if that changes through the material that you read, then please feel free to update that. The second deals with the statutory approval process. Now, my emphasis and my suggestion to you is to look at the State Works Development Act in Queensland and also look at the EPBCA Act at the Commonwealth level. Whilst you may wish to make comment about some other processes such as the Planning Act, primarily you'll be looking at the key pieces of legislation. So look at the bilateral agreement regime in this context and think about the statutory approval process as it works for the Queensland State Government and the Commonwealth Government. See how the two complement each other through that bilateral agreement regime. And I've referred you, of course, to the key stages of the environmental impact assessment an improvement process under the EPVCA. The third part, which is worth 10 marks, requires you to consider the additional information of the environmental impact statement. Now, as you would have seen, there's many examples of additional material or information which is provided. So I've selected one for you to comment upon, and that is the AEIS hydrodynamic and advection disbursement modelling technical report. So have a look at that, and what I'm looking for is an explanation about the modelling tools that are used to assess the range of hydrodynamic, water quality and coastal process impacts, and also consider the impact of offsets to compensate for significant residual impacts on the matters of national environmental significance. So we talked about offsets last week in a general term, so here's an opportunity for you to speak about offsets in a more particular instance. And then, of course, we have the issue to do with social impacts and the terms of reference. So I've given you links to the primary materials, but I do want you to look more broadly in relation to those matters. And if you find something has been updated, then please refer to the updated material. As indicated, this is a live matter, and I'd like the material to be presented in as an up-to-date format as possible. Now, there's no specific format for you to set out your assessment. You can have a look at my sample document, which is on the internet, on Moodle site. That'll give you some idea of the way I like to have material set out. I am keen for you to reference material and do so in terms of the Australian Guide to Legal Citations. All right, so if you have any questions in relation to the second assessment or the third assessment, then please ask through UCRU and we'll engage in some discussions. So in terms of referencing your work for the second assessment, again, look at the Australian Guide to Legal Citations as a handy reckoner. But if in doubt, the general rule is this: identify the source material by reference to its formal name if you can, and then identify the page or paragraph from which your material is drawn. So don't simply refer me to an executive summary. Refer me to the executive summary, name it in accordance with the way it's named, and then refer me to a page or paragraph number. If you refer to that document on a second occasion, on the next occasion, you can use the term IBID, but again, make sure that you refer to the page or paragraph number when doing so. I hope that provides you with some guidance in relation to the second assessment. All right, so this week's topic relates to environmental litigation and civil law. The material in the study guide that I've written is quite extensive, so I'll try to supplement rather than repeat that information. The first thing that you need to be aware of is this general concept of standing. By standing, I mean, what is an entitlement for a person to present themselves in court? And anyone that wants to take action in civil law for environmental litigation has to answer this question: do I have the right to agitate this matter? So at common law, the rights of an individual or organisation or company to agitate a matter are very strict, and there must be a special interest or special standing, sometimes referred to as a legitimate interest, at common law before a potential litigant is able to put his or her or their or its foot, as it were, in the door. So that's limited, but different rules apply in different circumstances. And generally speaking, the issue of standing is now governed by legislation rather than common law. And as a general principle, the standing rules have been progressively relaxed to allow more people to have an opportunity to litigate matters involving civil law, environmental litigation, than was previously the case, and certainly the case at common law.
Sorry, John, could I just ask a question? Is this where New South Wales is actually being quite slack in the standing process in regard to standing?
Well, perhaps depending on your perspective, either slack or progressive might be the term. Certainly the position in New South Wales is that standing rules have been relaxed considerably. Essentially in New South Wales, as I understand it, essentially anyone can claim standing. And whilst it's fair to say that in New South Wales, as is the case elsewhere, that regulatory authorities have had standing granted to them by legislation, community litigants have always faced a problem in terms of trying to establish an entitlement to standing when it comes to having their environmental dispute heard by a court or tribunal. So in the federal court, or say in the Queensland context, the Planning and Environment Court, those courts are restrained by legislation or empowered by legislation, as the case may be. In New South Wales, the situation about standing is relaxed to the point where it is essentially, for want of a better term, an open door policy. Kim, does that cover the sort of point that you're wanting to raise, or have I looked at something from a different perspective?
No, that's probably slack wasn't the word that I should have been using, but relaxed is probably
relaxed or liberal.
Yes, so political correctness there, but I do notice that I do notice that with what I'm working with at the moment in a range of areas with the EPA, there is a lot of issues that is completely different within New South Wales than what it is in Queensland, and I thought New South Wales always seems to be ahead of everything, but in this stage of my work, it's really not compared to Queensland.
And look, you've raised a good point there by making reference to the EPA. Certainly in Queensland, be aware that when it comes to environmental litigation, civil law, there is essentially this dichotomy between litigation that is based on issues to do with the Environmental Protection Act of 1994, as opposed to civil litigation, which is based on issues which are covered by the Planning Act of 2016, which superseded the Sustainable Planning Act of 2009. So, for example, in Queensland, when it comes to environmental protection litigation, have a look at section 505, where it states that someone whose interests are affected by the subject matter of the proceeding and someone else with leave of the court, even though they don't necessarily have a proprietary or material or financial or special interest, may bring proceedings in the court seeking to remedy or restrain an offence or threatened or anticipated offence against the Act. Now, we dealt with that to some degree last week when we talked about the Crowther decision. So as a reminder, that was Crowther against the Brisbane City Council, 2010 QCA 348. In that case, the court held that the applicant was entitled to bring an action in relation to a restraint against the council, that's the Brisbane City Council. And but the issue of standing still arose, and it was held in that case that merely to have an interest in the subject matter for intellectual or emotional concern, with the only advantage to be gained being the satisfaction of righting a wrong, is not to be someone whose interests are affected under the test. So you still need to establish standing to a degree, but it is much easier in that sense than certainly it was in the past. So be aware of the difference between standing in the context of EPA litigation as against planning litigation. And that can vary from state to state. So thanks for that, Kim. Is there anything further, or did I cover that point?
No, that's really good, John. Like, I understand where you're coming from. If we go back to probably the first assignment with Contempt of Court, I'm looking at things like within my work at the moment. Like, if the EPA was going to come in and, like, for argument's sake, do an audit, where do you stop and start with what you can say and what you can't say? like, because it's, to me, like, I feel like there's a whole range of things. It's like, this is really different for me to actually be dealing with. But you would actually have someone come in and say that what you've got is, you open up your doors and you tell us everything we want to know, and you've got no I don't know. It's sort of like, if you confess to something, can you be held liable? But it seems to be the EPAB it's going to give us no recourse. You know what I mean?
Okay, now that's an interesting topic, and we certainly raised that by talking about Section 505 and an ability for someone to seek an injunction. But that's slightly different, I think, to what you're talking about, where you're starting to talk about issues that relate to criminality, which is our topic for next week. But the general principle that a person is entitled to refrain from making a statement that might incriminate them applies in environmental law just as much as it does in other offence-based legislation. So people can claim privilege in relation to something which may, if the material was used against them, result in a prosecution. I hope that makes sense, Kim.
It sort of does, John. I'm thinking, going back to the first assignment, like if we were talking about John Fallon, he was a person that was a self-litigant, and he just blabbed a whole range of stuff out, and he was probably, like, I don't know if I can say this, but he was pretty stupid with what he did. If he had have called us, we would have been fine. We would have fixed everything for him. I'm pretty sure he's a good bloke. We've actually stayed in his park as well, which makes me like, in the range of that. But I'm not sure how you actually move forward when you actually, under the EPA, well, any environmental law stuff, everything says that, for me, when, like, I'm doing stuff from work, it says that basically we must disclose everything. If we don't disclose everything to do with any environmental protection issues, we must disclose that. So if there's a disclosure there, and then we disclose stuff, and then we put ourselves in the shit, basically.
No, I understand.
Where do we go from there? Like, you have to, yeah.
Yeah, that's probably more a discussion for next week. So perhaps if we could just come back to that one, if that's all right.
Sorry, John. Thank you.
No, that's fine. Thank you, Kim.
I'm jumping ahead.
No, it's good. But it's all to do with that issue of standing and people having an entitlement to have their say. So whilst we've talked about the state jurisdictional standing issues, be aware that at a Commonwealth level, there are certain entitlements for an applicant to seek an injunction. The standing tests referred to in Section 475 of the EPBCA, and an applicant for applying for judicial review must satisfy the standing test under Section 487 of the EPBCA. Just on that point, bear in mind that there is a difference then between the merits review application and a judicial review application. It's not always apparent readily, the difference between the two, but I think we're probably at the stage where we all know what a merits application is as opposed to a judicial review. So a merits review application is where a dissatisfied party applies for what is in effect a rehearing of the matter by the court or the tribunal, as the case may be, and that court or tribunal steps into the shoes of the decision maker and makes the best and preferable decision. In a judicial review application, the applicant seeks a decision of the court to the effect the decision maker has made a mistake at law. In other words, the decision maker has exhibited bias or exceeded jurisdiction or done something which means that the decision is not a binding decision, it's not made in accordance with our law. I mentioned that there's a distinction between the two, which is sometimes subtle. In that regard, have a look at a case of Fraser Coast Regional Council against Walter Elliott Holdings. It's 2016 QCA 19. So it's a recent decision. President McMurdo, as she was at that time, together with Justices Morrison and Atkinson, made the following comments. And they said, the proceedings for declaratory relief under statutory provisions like Section 456, that is 456 of the Sustainable Planning Act, which is now repealed and replaced by the Planning Act, are analogous to judicial review proceedings. So they're talking about declaratory relief under the statutory provisions. They are concerned with whether the impugned decision was validly made. It's not a merits appeal from fact finding. The Planning and Environment Court acting under Section 456 is not a planning authority. It's not empowered to simply set aside a decision of the council and replace it with its own. So when we're talking about seeking a declaration under certain provisions of the Act, we need to consider the issue of standing. Is this person entitled to be there? And then we have to go further and consider issues as to what type of remedy do you seek by way of the declaration, and what type of power does the court have, and what process does it undertake in order to answer that query. All right, so what I'd like to do now is deal with some issues under the Planning Act 2016. So of course this is all new because the Planning Act has only just come into effect. So Kim says 487 is the legislation. So thank you, Kim, for that one. All right, so the Planning Act, the first thing is who is able to lodge an appeal in the Planning and Environment Court or the Planning Tribunal, and if so, on what basis. So what I'm going to do is refer to the legislation. I'll share the screen and we'll look at the Queensland legislation. And hopefully I can share this now. With any luck, you're now seeing the Queensland legislation webpage for the Planning Act 2016. And you'll see from the index to the left that the important place to look is right down the bottom in Schedule 1, Appeals, which deals with appeal rights and parties to appeals. So I've now linked to that section, and it refers to Table 1, and Table 1 is here, which provides a summary, if you like, of parties' ability to appeal to the Planning and Environment Court and for certain matters to the Tribunal in relation to development applications, change applications, extension applications, infrastructure charges notices, conversion applications, and it provides four columns, giving a statement as to whether the applicant, the assessment manager, the co-respondent, if any, or the co-respondent by election, if any, are entitled to bring proceedings. And you'll see that that flows through for the balance of Table 1. So Table 1 sets out those appeals that may be made either to the tribunal or the court, and it relates to those matters that are identified in that clause. So let's take an example. Table 1, Item 1, deals with development applications, and it provides for appeals by applicants about decisions made in relation to their development application. So the appeal may be made to the P&E Court in relation to the application, but the appeal may also be made to the Development Tribunal about applications but only to the extent that they relate to the Building Act or some material change of use for classified buildings. So in other words, there are different rules that apply about where you should go depending on the nature of the application and the circumstances relating to that application. Now, Table 2 deals with issues to do with appeals to the Planning and Environment Court only. So these appeals from the Development Tribunal, they're appeals from eligible submitters or eligible advice agency appeals, and it also deals with things like compensation claims, appeals about registered premises, and decisions about particular local laws. So it really is, I guess, both simple and complex at the same time, in that you must consider carefully these tables when determining whether you are an eligible applicant to deal with issues and have appeal rights and able to go to the court or the tribunal, and then to further decide whether it is the court or the tribunal where you should proceed. Now, Table 3 deals with appeals to the tribunal only, and these appeals are about building advisory agencies or inspection of building works or particular decisions made under the Building Act, Plumbing Act or Drainage Act. So things of that nature are matters that should only proceed to the tribunal. All right, I'll stop the screen share there if I can manage to do that. All right, so as you can see, when it comes to looking at the issue of civil litigation, there's a whole range of things that you need to do before you even commence proceedings. Once you commence proceedings, particularly in the Planning and Environment Court and the Development Tribunal, things move quickly. So what does the Planning and Environment Court hear generally? Well, normally it deals with planning and development matters or environmental protection matters, coastal protection, fisheries, marine parks, nature conservation, vegetation management. So that's the kind of general scheme of what the Planning and Environment Court does. Now, who constitutes the court? Well, in Queensland, it is essentially district court judges who constitute the Planning and Environment Court. Not every district court judge has a commission to hear P&E matters, but those judges that do hear P&E matters in the Planning and Environment Court are district court judges. So you, and His Honour Judge Rackerman is the listing judge based in Queensland. So what type of proceedings then? So we know generally what the court deals with, and these are the issues such as planning and development and environment protection, as mentioned. So the Planning Act is the key piece of legislation when it comes to dealing with these sorts of proceedings. And those proceedings are development application matters. That would be the bulk of the work that it does, but also appeals about infrastructure charges, compensation, appeals from the Development Tribunal, and applications for declarations. We talked about that just a while ago, and contempt proceedings as well. So what do you do? How do you start proceedings? Let's assume that you've been through the process of determining whether you have standing, what's the provision upon which you rely, you've determined that you are eligible to go to the Planning and Environment Court, and you seek to appeal, for example, against a decision on a development application. What do? What's the first step? Well, the first step is file a notice of appeal. As you might expect, this is a prescribed form, and there are time limits that apply for starting an appeal in the Planning and Environment Court. So I'm going to refer you back to the legislation relevant to the decision, the Planning Act, more than likely, to determine the time limits that apply. Once you've lodged your notice of appeal, the second thing you need to do is serve the notice of appeal. And there are different people that you serve depending on the nature of the application. So if you wish to appeal against a decision approving a developer's development application under the Planning Act, then you serve your proceedings on the Chief Executive of the Department of Infrastructure, Local Government and Planning. You serve your proceedings on the Assessment Manager. Now that's normally the council. You serve your proceedings on any referral agency. So it might be a state government agency. And of course, you serve your proceedings on the applicant for the approval, which is the developer. If you wish to appeal against a decision on your own application, if you are, for example, the developer, then notify the Chief Executive, the Assessment Manager, the referral agency, if there is any, but also any principal submitter whose submission has not been withdrawn, or any advice agency treated as a submitter whose submission has not been withdrawn. So the key there is file your material, do so within time, and then serve it on the people that have a right to be heard in relation to the litigation. What do you do then? Now, bear in mind, this all moves very quickly. Once you start, you've got to be ready to go. And if you lodge the application, you have the onus of proof. It's your job to prove the case that you seek to establish, and you do so on the balance of probabilities. So let's assume the developer is the applicant. What does the developer do? Well, it'll apply for a directions order and do so within 3 months. It will file material and try to obtain what's called a directions hearing, which is step 4. So step 4, a directions hearing. At the directions hearing, the court issues a directions order, which sets out what the parties must do and the timeframes for doing so. Usually, the parties are represented by lawyers who come to an agreement beforehand, and they will hand up the draft directions order to the judge, who can accept it and make it an order, or may modify that directions order. So what's included in a directions order, which is made at the directions hearing? Well, very importantly, there's a great emphasis on ADR procedures in the Planning and Environment Court. And one thing that you need to include is a dispute resolution plan. So the whole process of alternative dispute resolution in the P&E court is formalised in a manner that is not the same as it applies in other courts. So it's quite different. It's very advanced. It's an excellent procedure. So we have this dispute resolution plan, and almost all disputes are resolved, or at least narrowed by agreement, before the final hearing. So I'm a nationally accredited mediator, and all mediators will work towards a full resolution, but failing resolution, we'll try to at least narrow the issues of concern so that when we do go to a hearing, we're dealing with a discrete number of items rather than a huge number of items. And we're focusing the attention of the court on what is the real dispute. Anyway, so this process of alternative dispute resolution in the P&E court is advanced, and the ADR registrar of the P&E court deals with case management conferences, will chair a without prejudice conference, and will also engage in enclaves, which is a meeting of experts. So expert enclaves through that process are very important as well. I should mention, as an aside, that I coordinate a unit called Alternative Dispute Resolution at Central Queensland University, which is Laws 12062, and we deal with this in a bit more detail in that unit. So once we've resolved our dispute resolution plan, we've engaged in the dispute resolution process, the matter might be resolved, but if not, we then have to work towards a hearing of the matter. And the next step, step 6, is a review hearing. We call this pre-call over. And a review hearing will typically occur a few weeks before the final hearing. The court wants to finally check the progress of the matter, and the parties are expected to do certain things at that review hearing. Have they complied with all of the directions in the directions order? If not, what's outstanding and what are they doing about it? And ultimately, the court will say this: are you ready for the final hearing? Once you say, yes, I'm ready for the final hearing, essentially it's very hard to go back on that. So make sure you're ready to go. The pre-call-over review hearing precedes the, so this review hearing precedes what's called the final call-over hearing, and it's the final review, and that's where the judge will make a particular sitting and allocate dates for the hearing. So that might be in Brisbane, but it could be elsewhere as well. And then, of course, the final step, step 8, is the hearing itself. Okay, well, that's a very quick run-through of the process of civil litigation in environmental law, with an emphasis on Queensland and an emphasis on environmental litigation under the Planning Act. But as I mentioned at the outset, the process is broader than that, and it does involve issues that may relate to seeking an injunction or declaration, for example, under the Environmental Protection Act. Crowther's case is a good example of that, and it may involve matters that relate to federal jurisdiction, which might involve issues to do with the federal court or the federal circuit court. So I've concentrated primarily on the Queensland regime. Have a look at your notes in relation to week 9, and there's quite a lot of material there for you to consider as well.
Excuse me, John. I'm just wondering, like, I'm really struggling with the summary in regard to Brigginshaw and Brigginshaw case. How does that become something to do with environmental law when it's a family law court issue? I know the foundations of it, but why is someone bringing that into perspective when it's not really an environmental law issue? It's standard. I know it's a standard of proof. We're getting back down to statutory interpretation. How does that work?
Well, you're right.
So, I'm still really confused.
Okay, so when we talk about the Brigginshaw test, it does derive from a case called Brigginshaw and Brigginshaw, and this is the way it works. So in civil proceedings, the standard of proof is on the balance of probabilities. The onus of proof is on the party that has to prove it. So the applicant generally has the onus of proof, and they need to prove their case on the balance of probabilities, that it's more likely than not. So even though the general principle in Brigginshaw was Brigginshaw and Brigginshaw, it has general application. We use it a lot when we're dealing with civil procedure. And Brigginshaw, the test really means this, that the more important the consequence, the greater the quality of proof that needs to be provided to the court before the court can truly be satisfied on the balance of probabilities that it should accept the case of the applicant. So if we're talking about a minor dispute, something that's really quite simple and the consequences are not great, the court won't need a lot of evidence before it will necessarily conclude on the balance of probabilities one way or the other. But if we're talking about very important matters, matters where the decision of the court will have considerable consequence, then the court wants to ensure that it gets it right, and it will insist on having good evidence and substantial evidence to support its finding about the balance of probabilities in relation to the matters before it. So I hope that provides some explanation, Kim. Even though Brigginshaw is a particular case about certain matters, it's now a case which is referred to in general application. Does that help clear it up, Kim?
Yes, John, but no. I've been looking at this case for so long, and I'm just going, how does it go from all the different relevant law assumptions? Like you can go from crim, you can go from torts, you can go from environmental law. There's a whole range of things that this particular case broadens out to be something that it's not. And with the cases that we were looking at in the first assignment, I guess, it's just like, I don't understand what's there. I really don't understand what's there.
Yeah, Brigginshaw wouldn't apply in criminal proceedings because the standard of proof is different. That's the balance of probability, sorry, the beyond reasonable doubt. But generally that Brigginshaw test applies for civil proceedings across the board. And I guess one way of explaining why Brigginshaw is so often referred to and considered by courts is that it hasn't actually been incorporated to a great degree in our legislation, although there is a reference to it, as I recall, in the UCPR, but I can't recall the specific rule at the moment. But that's, for want of a better term, it's more a general description rather than necessarily relying on the specific case.
John, I think you're right. I have read that somewhere, and I don't think it's there, but it's not there. But I have made reference to that. Yeah.
Okay. But feel free to raise that again in UCRU, and we can explore that in greater depth, and I'll try and find some further materials relevant to Brigginshaw.
Thanks, John.
Okay. Thanks, Kim. All right. Well, look, if there are no further questions or comments, we might wrap it up for this evening. Thank you very much for your patience. For those of you watching this as a recorded session, hopefully you'll ask any questions about the second assessment, if you have any, through UCRU, and we can collectively deal with those questions and provide a response. The questioning through UCRU is advantageous, I think, in that I'm then not seen as favouring individual students. I'm providing a general answer for everyone to consider. And also, very often the case that students help each other in terms of their queries, and that's a great advantage for me as well.
Hi, John. Before you go, yeah, look, I would really recommend that our cohort could actually come together very quickly, because there's a lot of questions and there's a lot of fantastic people that signed up for this course. If they can actually, share their, the whole environmental issues that they've got, would be fantastic. Thank you very much, John.
And I agree, Kim. So those of you that are watching the recorded session, come on board. Let's have you attend the Zoom session on a Tuesday evening, and let's engage to a greater degree in our discussions about environmental law through UCRU. Okay, all the best. Thank you, Kim, and we'll see you all next week. Bye then.
Thanks, John. Bye.